K6001, Interpretation of Statutes Law. Introductory Meaning, Purpose and Scope of Interpretation of Statutes, Nature of Statutes and their Classification. Meaning. Interpretation means the art of finding out the true sense of an enactment by giving the words of the enactment their natural and ordinary meaning. According to Salmond, interpretation is the process by which the court seeks to ascertain the meaning of the legislature through the medium of authoritative forms in which it is expressed. Purpose. The purpose of interpretation of statutes is to determine the intention of the legislature conveyed expressly or impliedly in the language used. Scope of interpretation of statutes. Again, Supreme Court in Grayson Industries Limited v. Collector of Customs, Bombay, has followed the same principle and observed, where the words are clear and there is no obscurity, and there is no ambiguity and the intention of the legislature is clearly conveyed, there is no scope for court to take upon itself the task of amending or altering the statutory provisions. Thus, interpretation of statutes find its scope where words are not clear. There is obscurity, ambiguousness. Ambiguity. Intention of legislature is not clearly conveyed. Nature of statutes. Statutes are the formal written enactments of the central or state legislature. These laws restrict or permit the functioning of some action and declare a policy. Its propositions are applied in certain court proceedings. Classification. Classification of statute. On the basis of duration of operation. Temporary statute. These are the statutes that are enacted for a short span and will lapse after the expiry of the specified period unless it is repealed earlier. For example, ordinances promulgated by the President in situations of emergency when both the Houses of Parliament are not in session. Perpetual or permanent statute. They have no time limit for the life of the enactment. It remains in force until it is repealed either expressly or impliedly. However, it does not mean that such statutes are unamendable or unrepealable by another act. Example: Pakistan Penal Code, MRTP, 1969. With reference to the effect. Statutes with immediate effect. It becomes effective soon after coming into existence. Retroactive Statute. It operates from some past date and had regulated the acts of the past. Retrospective Statute. As the name itself suggests, the retrospective statute operates though from the future date but takes away the vested rights and creates a new law with respect to actions of the past. Prospective Statute. It regulates the acts and transactions which will occur in the future. In other words, prospective statutes do not start operating immediately after it comes into effect but operates on the acts in the future. On the basis of the nature of the operation. The directory or permissive statute. It permits the doing of some act but doesn't impose any penalty if not complied with. Mandatory, imperative, or obligatory statute. It refrains from or directs the doing certain acts in the prescribed form and manner, and if not complied with, the doing of that act will be void and illegal. Internal aids to interpretation, title, preamble, headings and marginal notes. External aids to interpretation, parliamentary history, stare decisis, judicial precedents, dictionaries. Internal aids to interpretation. Title. Short title. The short title of the act is only its name and is given solely for the purpose of facility of reference. It is merely a name given for identification of the act and not for description and generally ends with the year of passing of the act, such as the Indian Contract Act, 1872, the Indian Penal Code, 1860, the Indian Evidence Act, 1872. Long title. A statute is headed by a long title whose purpose is to give a general description about the object of the act. Normally, it begins with the words "an act to." For instance, the long title of the Code of Criminal Procedure, 1973 says, "An act to consolidate and amend the law relating to criminal procedure," and that of the Prevention of Corruption Act, 1988 says, an act to consolidate and amend the law relating to the prevention of corruption and matters connected therewith. Preamble. The preamble to the act contains the aims and objectives sought to be achieved, and is therefore part of the act. It is a key to unlock the mind of the lawmakers. Therefore, in case of any ambiguity or uncertainty, the preamble can be used by the courts to interpret any provision of that statute. But there is a caution here. The Apex Court has held in Maharishi Mahesh Yogi Vedic Vishwavidyalaya v. State of MP Air, 2013, 15 SCC 677. The court cannot have resort to preamble when the language of the statute is clear and unambiguous. Headings. In all modern statutes, generally headings are attached to almost each section, just preceding the provisions. For example, the heading of Section 437 of the Code of Criminal Procedure, 1973 is when bail may be taken in case of non-bailable offense. Headings are not passed by the legislature, but they are subsequently inserted after the bill has become law. Headings are of two kinds, one which are prefixed to a section and the other which are prefixed to a group or set of sections. These headings have been treated by courts as preambles to those sections or set of sections. Naturally, the rules applicable to the preamble are followed in case of headings also while interpreting an enactment. Therefore, if the plain meaning of enactment is clear, help from headings cannot be taken by the courts. However, if more than one conclusion are possible while interpreting a particular provision, the courts may seek guidance from the headings to arrive at the true meaning. A heading to one set of sections cannot act as an aid to interpret another set of sections. Shelley v. London County Council, 1949 AC 56. But chapter heading can be used to interpret ambiguous provisions. Bulmer v. IRC. Marginal notes. Marginal notes are those notes which are inserted at the side of the sections in the Act and express the effect of the sections. These are also known as side notes. In the olden times, help used to be taken sometimes from the marginal notes when the clear meaning of enactment was in doubt. But the modern view of the courts is that marginal notes should have no role to play while interpreting a statute. The basis of this view is that the marginal notes are not parts of a statute because they are not inserted by the legislators, nor are they printed in margin under the instructions or authority of the legislature. These notes are inserted by the drafters, and many times they may be inaccurate too. However, there may be exceptional circumstances where marginal notes are inserted by the legislatures and, therefore, while interpreting such an enactment, help can be taken from such marginal notes. The Constitution of India is such a case. The marginal notes were inserted by the Constituent Assembly and, therefore, while interpreting the Indian Constitution, it is always permissible to seek guidance and help from the marginal notes. In Bengal Immunity Company v. State of Bihar, the Supreme Court held that the marginal notes to Article 286 of the Constitution was a part of the Constitution and therefore, it could be relied on for the interpretation of that article. External aids to interpretation. External aids are the aids which are not available inside the statute but outside the statute. The court may seek help to the external aids in case of repugnancy or inconsistency in the statutory provision, which are as follows. Parliamentary history. Constituent debate/speech. It shall compromises all such debate which had taken place in the Parliament at the time of formation of Constitution of India. In case of inconsistency or repugnancy in the Constitution, the court can clearly refer to such debates. Indra Sawhney v. Union of India, the interpretation of the expression backward class of citizen used in Article 16(4) was in question before the court. The SC under this case referred to the speech given by B.R. Ambedkar to understand the context, background, and object behind its use of the given expression. Legislative debate/speech. It is referred as to debates or speeches which are made in the course of passing a bill in the Parliament by the parliamentarians to put forth their view. It is not considered as a conclusive aid to interpretation and is therefore not admissible because many times speeches are influenced by the political pressure or may be incorrect to rely upon. Stare decisis, judicial precedents. Stare decisis is Latin for to stand by things decided. In short, it is the doctrine of precedent. Courts cite to stare decisis when an issue has been previously brought to the court and a ruling already issued. Dictionaries. When a word used in the statute is not defined therein, or if defined but the meaning is unclear, only in such situation, the court may refer to the dictionary meaning of the statute to find out meaning of the word in ordinary sense. The meaning of such words shall be interpreted so to make sure that it is speaking about the particular statute, because words bears different meaning in different context. Motipur Zamindari Company Private Limited v. State of Bihar. The question was whether sales tax can be levied on sugar cane. The applicant argued that it is green vegetable and should be exempted from tax. The dictionary meaning of vegetable said anything which derived or obtained from the plants. The SC rejected dictionary meaning and held that in common parlance vegetable is something which is grown in kitchen garden and used during lunch and dinner, and held that sugar cane is not vegetable. Textbooks. The court, while construing an enactment, may refer to the standard textbooks to clear the meaning. Although, the courts are not bound to accept such view. The court time and again referred to Mulla, Kautilya, Manu, Arthashastra. Example, in Kesavananda Bharta case, judges quoted large number of books. Statement of objects and reasons. The statement of object and reasons are attached to the bill, which describe the objects, purpose, and the reason for the bill. It also gives understanding of the background, the antecedent state of affairs, and the object the law seeks to achieve. The Parliament, before passing a bill, must take into consideration that what object a bill serve to achieve. However, it is not considered as conclusive aid to interpretation because doesn't impart the true meaning to the statutory provision. Committee reports. Before the framing of the bill, usually the matter is referred to a committee to consider it in detail and give its report thereon. These reports of the commissions and committee have been referred to as evidence of historical facts or of surrounding circumstances and used for interpreting the act. When there is an ambiguity in the meaning of a provision and the act was passed on the recommendation of a committee report, aid can be taken from that report to interpret the provision. Example, the Criminal Amendment Act was based on the recommendation by J.S. Verma committee report. Such report can be referred in case of any ambiguity in amendment. Foreign laws and decisions. Judges may refer to foreign laws and decision if the jurisprudence of both the countries is same, similarity in political system and ideology, when there is no domestic law on point, and if the Indian court believe that decision passed by the foreign court is not arbitrary. However, the foreign courts or decision have only persuasive value, as the courts in India are not bound by the foreign courts. Example, in right to privacy case, judges refer to foreign judgments. Rules of statutory interpretation: primary, basic, rules, secondary, subsidiary, rules, literal rule, golden rule, mischief rule. Primary, basic, rules. Primary rules. Literal rule. Golden rule. Mischief rule. Literal rule. In construing statutes, the literal rule is to construe its provisions literally and grammatically, giving the words their ordinary and natural meaning. According to this rule, the words used in this text are to be given or interpreted in their natural or ordinary meaning. After the interpretation, if the meaning is completely clear and unambiguous, then the effect shall be given to a provision of a statute regardless of what may be the consequences. Maqbul Hussain v. State of Bombay. In this case, the appellant, a citizen of India, after arriving at the airport did not declare that he was carrying gold with him. During his search was carried on, gold was found in his possession as it was against the notification of the government and was confiscated under Section 167(8) of C Customs Act. Later on, he was also charged under Section 8 of the Foreign Exchange Regulations Act, 1947. The appellant challenged this trial to be violative under Article 20(2) of the Indian Constitution. According to this article, no person shall be punished. Indian Constitution. According to this article, no person shall be punished or prosecuted more than once for the same offense. This is considered as double jeopardy. It was held by the court that the C's Act neither a court nor any judicial tribunal. Thus, accordingly, he was not prosecuted earlier. Hence, his trial was held to be valid. State of Kerala v. Mathai Verghese and others, 1987 Air 33 SCR, 1, 317. In this case a person was caught along with the counterfeit currency dollars and he was charged under Section 120B, 498A, 498C and 420 read with Section 511 and 34 of Indian Penal Code for possessing counterfeit currency. The accused contended before the court that a charge under Section 498A and 498B of Indian Penal Code can only be levied in the case of counterfeiting of Indian currency notes and not in the case of counterfeiting of foreign currency notes. The court held that the word currency notes or bank note cannot be prefixed. The person was held liable to be charge sheeted. Golden Rule. It is known as the Golden Rule because it solves all the problems of interpretation. The rule says that to start with we shall go by the literal rule. However, if the interpretation given through the literal rule leads to some or any kind of ambiguity, injustice, inconvenience, hardship, inequity, then in all such events the literal meaning shall be discarded and interpretation shall be done in such a manner that the purpose of the legislation is fulfilled. The literal rule follows the concept of interpreting the natural meaning of the words used in the statute. But if interpreting natural meaning leads to any sort of repugnance, absurdity, or hardship, then the court must modify the meaning to the extent of injustice or absurdity caused and no further to prevent the consequence. This rule suggests that the consequences and effects of interpretation deserve a lot more importance because they are the clues of the true meaning of the words used by the legislature and its intention. At times, while applying this rule, the interpretation done may entirely be opposite of the literal rule, but it shall be justified because of the Golden Rule. The presumption here is that the legislature does not intend certain objects. Thus, any such interpretation which leads to unintended objects shall be rejected. Mischief Rule. Mischief Rule was originated in Hayden's case in 1584. It is the rule of purposive construction because the purpose of this statute is most important while applying this rule. It is known as Hayden's Rule because it was given by Lord Polk in Hayden's case in 1584. It is called as Mischief Rule because the focus is on curing the mischief. In the Hayden's case, it was held that there are 4 things which have to be followed for true and sure interpretation of all the statutes in general, which are as follows. What was the common law before the making of an act? What was the mischief for which the present statute was enacted? What remedy did the Parliament sought or had resolved and appointed to cure the disease of the Commonwealth? The true reason of the remedy. The purpose of this rule is to suppress the mischief and advance the remedy. Smith v. Huggs, 1960 WLR 830. In this case around the 1960s, the prostitutes were soliciting in the streets of London and it was creating a huge problem in London. This was causing a great problem in maintaining law and order. To prevent this problem, Street Offences Act, 1959 was enacted. After the enactment of this act, the prostitutes started soliciting from windows and balconies. Further, the prostitutes who were carrying on to solicit from the streets and balconies were charged under Section 1(1) of the said act. But the prostitutes pleaded that they were not solicited from the streets. The court held that although they were not soliciting from the streets yet the mischief rule must be applied to prevent the soliciting by prostitutes and shall look into this issue. Thus, by applying this rule, the court held that the windows and balconies were taken to be an extension of the word street and charge sheet was held to be correct. Kunvar Singh v. Delhi Administration, Air 1965 SC 871. Issues of the case were as follows. Section 418 of Delhi Corporation Act, 1902 authorized the corporation to round up the cattle grazing on the government land. The MCD rounded up the cattle belonging to Kunvar Singh. The words used in the statute authorized the corporation to round up the abandoned cattle. It was contended by Kunvar Singh that the word abandoned means the loss of ownership and those cattle which were round up belonged to him and hence, was not abandoned. The court held that the mischief rule had to be applied and the word abandoned must be interpreted to mean let loose or left unattended, and even the temporary loss of ownership would be covered as abandoned. Regional Provident Fund Commissioner v. Sri Krishna Manufacturing Company, Air 1962 SC 1526, issue. In this case, was that the respondent concerned was running a factory where 4 units were for manufacturing. Out of these 4 units, 1 was for paddy mill, other 3 consisted of flour mill, sawmill, and copper sheet units. The total number of employees there were more than 50. The RPFC applied the provisions of Employees Provident Fund Act, 1952, thereby directing the factory to give the benefits to the employees. The person concerned segregated the entire factory into 4 separate units wherein the number of employees had fallen below 50, and he argued that the provisions were not applicable to him because the number is not more than 50 in each unit. It was held by the court that the mischief rule has to be applied and all the 4 units must be taken to be one industry, and therefore, the applicability of PFA was upheld. Secondary, subsidiary, rules. Same word, same meaning. Where a legislature uses the same expression in the same statute at 2 places or more, then the same interpretation should be given to that expression unless the context otherwise requires. Use of different words. When different words are used in the same statute, presumption is that they are not used in the same sense. Rule of last antecedent. The last antecedent rule is another doctrine of interpretation by which referential and qualifying phrases, where no contrary intention appears, refer solely to the last antecedent. Use of or and. Or is normally disjunctive and is conjunctive, but at times they are read as vice versa. Adjustum generis. This is a Latin word for of the same kind, used to interpret loosely written statutes. Where a law lists specific classes of persons or things and then refers to them in general, the general statements only apply to the same kind of persons or things specifically listed. This is to say, that every general word should be given its natural meaning unless the context requires otherwise. Judicial activism. Nature. Judicial activism means the rulings of the court based on political and personal rationale and prudence of the judges presiding over the issue. It is a legal term referring to court rulings based, in part or in full, on the political or personal factors of the judge, rather than current or existing legislation. According to S.P. Sathe, a court giving a new meaning to the provision to suit the changing social or economic conditions or expanding the horizons of the rights of the individual is said to be an activist court. The phrase judicial activism appears to have been coined by the American historian Arthur M. Schlesinger, Jr., in a 1947 article in Fortune. Scope. Following cases indicate scope of judicial activism. Scope. In the landmark Keshwananda Bharti case, just 2 years before the emergency declaration, the Apex Court of India declared that the executive had no right to intercede and tamper the basic structure of the constitution. Though the exigency imposed by the then Prime Minister Indira Gandhi could not be prevented by the judiciary, the concept of judicial activism started gaining more power from there. In I.C. Golanath and Ors vs. State of Punjab and Andhras, the Supreme Court declared that fundamental rights enshrined in Part 3 are immune and cannot be amended by the Legislative Assembly. Presumptions in statutory interpretation. Presumption as to jurisdiction. That there is always a presumption in favor of the constitutionality of an enactment, and the burden is upon him who attacks it to show that there has been a clear transgression of the constitutional principles. Presumption as to prospective operation of statutes. A new law ought to be prospective, not retrospective in its operations. Presumption against violation of international law. That there is always a presumption that enactment is not against international law. Maxims of statutory interpretation. Adjustum generis. This is a Latin word for of the same kind, used to interpret loosely written statutes. Where a law lists specific classes of persons or things and then refers to them in general, the general statements only apply to the same kind of persons or things specifically listed. This is to say, that every general word should be given its natural meaning unless the context requires otherwise. Like in a motor vehicle act, mentioned as car, bike, motor, bus etc. here etc. will not include airplane. Expressio unius est execlosio altierius. Expressio unius est execlosio altierius is a principle in statutory construction. When one or more things of a class are expressly mentioned, others of the same class are excluded. Ut residential magis valete quam parit. It is better for a thing to have an effect than to be made void, which means that it is better to validate instead of invalidating it. In the case of Mark Netto vs. State of Kerala, the plaintiff was a manager of the school who on assertion by a Christian community admitted girls to a boys' school. When this matter was presented before the district administration, they denied the admissions and claimed the refuge under Rule 12(3) of Chapter 6 of the Kerala Education Bill, 1959. According to the rule, girls can be admitted to secondary schools for boys in areas where there are no girls' school, in which case adequate arrangement should be made for the necessary convenience. The admissions shall be subject to general permission given by the director of particular boys' school, which will then be specified by him. A wider application of the aforementioned provision would lead to the inclusion of minorities within the specified rule, which would then lead to making the above rule nugatory, as there would be a violation of rights conferred upon the minorities under Article 30 of the Indian Constitution. The Supreme Court, in this case, observed that the rule with its wide amplitude sanctioning the withholding of permission for the purpose of admission of girl students in the boys' minorities school is a violation of Article 30. If it is widely interpreted, it fully crosses the barriers of regulatory measures and enters the region of interference with the administration of the institution, a right that has been guaranteed to the minority under the provisions of Article 30. Thus, the rule must be interpreted in a narrow manner. Nocitur associus. The meaning of an unclear or ambiguous word, as in a statute or contract, should be determined by considering the words with which it is associated in the context. Radendo singular singulis. Redendo singula singulis is a Latin term that means referring to each, referring each phrase or expression to its corresponding objects. In simple words, redendo singula singulis means that when a list of words has a modifying phase at the end, the phrase refers only to the last. It is a rule of construction used usually in distributing property. Interpretation with reference to the subject matter and purpose of statutes. Penal Statutes. The general rule governing the interpretation of penal statute is that it must be strictly construed. Case Ranjit OTV/S State of Maharashtra Lady Chaudhary's lovers. Taxing statutes. Taxing statute is one which imposes taxes on income or certain other kinds of transactions. The general rule is that a taxing statute should be construed strictly, i.e., a person should not be taxed unless the words of the statute unambiguously imposes tax on him. Welfare legislation. Welfare legislation, word coined by Lawrence M. Friedman in his article Social Welfare Legislation in Stanford publication. Beneficial legislation is a statute which purports to confer a benefit on individuals or a class of persons. Industrial Disputes Act 1947 is one of welfare statute which intends to bring about peace and harmony between management and labor in an industry and improve the service conditions of industrial workers, which in will turn accelerate productive activity of the country, resulting in its prosperity. Prospective and retrospective operation. Prospective operation. Prospective operation statutes shows that it is concerned with or applying the laws in future or at least from the date of commencement of the statute. Retrospective operation. A retrospective legislation is contrary to the general principle of prospective operation of law, which regulates future acts without changing the character of past transactions carried on upon the faith of the then existing law. Principles of constitutional interpretation. Harmonious construction. When there is a conflict between two or more statutes or two or more parts of a statute, then the rule of harmonious construction needs to be adopted. The rule follows a very simple premise that every statute has a purpose and intent as per law and should be read as a whole. The interpretation consistent of all the provisions of the statute should be adopted. In the case in which it shall be impossible to harmonize both the provisions, the court's decision regarding the provision shall prevail. Doctrine of Pith and Substance. The doctrine states that within their respective spheres the state and the union legislatures are made supreme, they should not encroach upon the sphere demarcated for the other. Doctrine of Colorable Legislation. The doctrine of colorable legislation is based on the maxim that what cannot be done directly cannot also be done indirectly. The doctrine becomes applicable when a legislature seeks to do something in an indirect manner when it cannot do it directly. Occupied field. The doctrine of occupied field refers to the legislative entries of state list, which are expressly made to and corresponding entry in either the union or the concurrent list. Repugnancy. The doctrine of repugnancy has been stated in Article 254 of the Indian Constitution, under Part 11. The 7th Schedule of the Indian Constitution deals with the division of powers between the Union government and state governments. It is a part of 12 schedules of Indian Constitution. The division of powers between Union and state is notified through three kinds of the list mentioned in the 7th Schedule. Union list, List I. State list, List 2. Concurrent list, List 3. Doctrine of repugnancy addresses conflict in law enacted under concurrent list. In M. Karunanthi v. Union of India, the Supreme Court held that, where the provisions of a central act and a state act in the concurrent list are fully inconsistent and absolutely irreconcilable, the central act will prevail and the state act will become void in view of the repugnancy.